Welcome viewers to YouTube channel Kanooni CHARCHA. Today I am going to discuss a new judgment of Supreme Court of India, the State of Kerla versus Prabhu. It is dated 20th of August 2024. It is a division bench, two-bench judgment of Supreme Court of India. Justice C.T. Ravikumar and Justice Sanjay Kaul were the part of this two judges bench. Title is, I think I have already mentioned, to spoken, State of Kerla versus Prabhu. It is a case of NDPS Act. Excise, what are the facts of the case? I will narrate. On 10th of January 2019, during the course of patrol duty by the excise inspector, two 0.050 kg of ganja was found concealed in a bag in the possession of the accused. It was recovered and seized. This is the FIR was accordingly registered. FIR, you may say, and complaint or proceeding initiated for commission of offence under section 20B, small b, second Roman second, and big B of NDPS Act. After inquiry, investigation, you may say, a complaint charge sheet was filed before the special judge. Special judge, after this, appreciating the oral testimony of PW1 to PW4 and other documentary evidence, maybe Caesar memo and the FSL and all other relevant evidence, convicted the accused for the commission of the offence I have already mentioned, and sentenced the accused, I think Prabhu Kumar, to undergo imprisonment for 5 years and a fine of rupees 50,000. In default of payment of fine, he was ordered to undergo rigorous imprisonment for 6 months. Obviously, in the state was aggrieved by this order and approached the Honorable High Court. Oh, sorry, the accused, because this is a conviction case, the accused felt aggrieved. Obviously, he was sentenced, convicted and sentenced. He went in appeal before the Honorable High Court of Kerala at this Ernakulam. It may be a bench of the High Court there. The High Court acquitted the accused, reversed the finding of conviction and sentence of the trial court, special court. The main point of discussion in this episode and earlier discussed, appreciated, considered, is the section 50 of the NDPS Act. The viewers who are advocates, this law interns, law graduates, and judges, particularly the special judges who are dealing the cases under NDPS Act, are knowing that section 50 of the NDPS deals with the personal search of the accused at the time is intercepted and thereby detained, arrested after a search and personal search. This section relates to this personal search. But in the present case, as the recovery was of ganja, 2 kg and 50 grams was from the bag the accused was carrying with him. It is not from his purse. This is now point is there should be a strict compliance of section 50 when the recovery is from the bag, or it is only requires in the cases where there is personal search of the accused. This is the moot point in this case. Now, the trial court, I have already mentioned that conviction is convicted and sentenced. However, High Court acquitted by applying a judgment of its own High Court, Kerala High Court. High Court applied its own judgment, earlier judgment. It is SADIK, SIDHIK versus State of Kerla. It is a judgment of 2018. I will what feeling aggrieved by the judgment. I will read out the para 5 so that the viewers understand how the High Court of Kerala overturned the judgment of conviction and sentence of the trial court special judge. Feeling aggrieved by the judgment of conviction, the respondent Hayden took up the matter in appeal, which ultimately culminated in the impugned judgment dated 23rd of May 2023. This is judgment of acquittal which is assailed in this criminal appeal. With the case which we are discussing of the Honorable Supreme Court of India is scanning of the impugned judgment. Judgment of the would reveal that judgment of conviction was interfered with then reversed by the High Court. Now we are here discussing in this para judgment of the High Court, how the trial court judgment was overturned on the ground failure to comply with the formalities prescribed under section 50 of NDPS Act rendered the search and seizure illegal. This was opinion of the Honorable High Court of the Kerala, that the search and seizure affected in the matter was illegal. There is a violation of section 50 and they have relied upon the judgment I have referred. Obviously to hold so, the High Court has relied on its decision in SADIK, you may say, versus State of Kerala as well. Then now para 6 deals with the how the Honorable Supreme Court of India, this to bench appreciated, considered the earlier judgment of its Supreme Court of India, its own, and reversed the finding of the Honorable High Court of Kerala. Reverse the finding. Now I will read para 6. This seems to be relevant. The appellant state raised the contention that reasoning of the High Court for reversing the conviction of the respondent and acquitting him that the mandatory formalities provided under section 50 of the Act were not complied with and thereby the search and seizure were rendered illegal is contrary to the law. Contrary to the, this is what High Court has held as while acquitting the accused. They are referring that, and thereby search and seizure were rendered illegal is contrary to the law. The exercise of finding returned by the High Court is contrary to the law laid down by the court in view of the indisputable factual position that contraband was recovered from the bag in possession of the respondent. It is not a dispute. Sufficient evidence available, and it remains undisputed that recovery was effected from the bag of the accused. Now, this is the contention, a proved fact referred by the employer's counsel, the state's counsel, to buttress the said contention, learned counsel of the appellant relied on two-bench decision of this court in Rajan Kumar Chadda versus State of Himachal, reported in 2023. Now, they are now discussing a mere perusal of the said judgment. This judgment of Rajan Kumar Chadda said would reveal that after referring to the previous judgments of this court having presidential value, including the decisions in state of Punjab versus Baldev Singh and in state of Himachal Pradesh versus Pawan Kumar, this court held us. This is now the para 132 of Ranjan Kumar Chadda of the Supreme Court of India. This is 132 page of that judgment, Ranjan Kumar Chadda's judgment. It is referred in para 6 of this judgment. This order judgment in criminal appeal. For all the foregoing reasons, we are of the view that High Court was justified in holding that appellant guilty of the offence under NDPS Act, and at the same time High Court was also correct in saying that section 50 of the NDPS Act was not required to be complied with when the recovery is from the bag. This is similar situated case as is available. The facts, there is a recovery. In this case, Rajan Kumar Chadda from the bag, and similarly, in this case also recovery of the contraband ganja is also from this bag. Now it is a settled position now. When there is a recovery, there is a personal search of the accused, and which lead to a recovery of some contraband, which is prohibited under NDPS Act. Obviously, this search is to be made from the magistrate. Now, law has departed. There are judgments, finality has attained of the judgment, which says that it is the right of the accused to have a personal search from the magistrate. No doubt, the section 50 envisages that such accused can make an option for having a search either from the magistrate, from the gazetted officer. But gazetted officer, we have seen, I remain the special judge under NDPS Act, and point that the police during investigation or any of the empowered officers under this NDPS, they prefer to have a search of the accused from their own officers, the gazetted officers maybe. Now, with this, the law is attained finality with the coming of the Supreme Court judgment that it is the right of the accused to be get searched under section 50 of NDPS only from the magistrate. Now, no defense of the police of the state be entertained that such can be from this any other gazetted officer or any of the gazetted officer. The search must be before a magistrate. Now, however, in the present case, there is recovery from the bag of the contraband. Obviously, the provisions of section 50 as per the Supreme Court in this judgment is not applicable. Now, I will go. Now, the judgment of Ranjan Kumar Chadda seems to have followed by the Honorable Supreme Court. I will read out the para 8. in the said circumstance in the light of a law laid down by this court in Rajan Kumar Chadda, it can only be added that understanding of law by the High Court on the said issue of requirement to comply with Section 50 of the NDPS is contrary to the law laid down by this. What the Supreme Court's observation here that they have drawn the legal conclusion that the High Court has said that there is a violation of Section 50 of NDPS Act, but it is against, contrary to the viewpoint taken by the Supreme Court of India in Ranjan Kumar Chadda. Accordingly, now I will go to para 9. I think it is in that view of the matter. This also relates to the crux of the judgments. The impugned judgment cannot be sustained. The High Court judgment of Kerala, and that was judgment of acquittal, and it requires interference. According to the impugned judgment, whereunder respondent was acquitted, stand set aside, and as necessary, sequel be restored the judgment of the trial court to the extent it found guilty the respondent under Section 20B, second B of NDPS Act. Then there was a learned amicus curiae appearing for the respondent. Right? The accused was not having its own counsel, his own counsel. The friend of court appears to have assisted the court. This amicus curiae appearing for the respondent would submit that the respondent had actually undergone 4 years punishment, 4 months and 21 days. 4 years, 4 months and 21 days of incarceration point pursuant to the order of conviction. A perusal of the Section 20B, second B of the NDPS Act would reveal that no minimum sentence is prescribed under, though it provides that imprisonment may extend to 10 years and with the fine of rupees 1 lakh. Now, lastly, what the Supreme Court of India has did, they have reduced the punishment sentence point. The conviction remains for the commission of offence for which he was earlier convicted and sentenced, but sentence was reduced and to the imprisonment already undergone, and the fine amount also remained the same, and the accused was directed to deposit the same within 30 days from today. Otherwise, he has to face a punishment in default. This, however, we make it clear that in case of failure on the part of the respondent in affecting payment of a fine, rupees this 50,000 within stipulated time, he shall undergo the default sentence imposed by him by the trial court as per its judgment. Then he has to undergo this imprisonment in lieu of the fine if he is not capable of paying the depositing the fine. This is the judgment I have discussed here. No doubt now most of the lawyers, defense judges, special judges knows about the Section 50. About Section 50 of NDPS, formalities and compliance how to be made. But still, in the present case, the High Court has committed breach of this settled Rajan Kumar Chadda judgment on Kerala High Court and followed its own judgment and acquitted the accused, which has led to miscarriage of justice as per the this NDPS Act. Accordingly, Supreme Court of India set aside this order of acquittal of the High Court and restored this judgment of the conviction and sentence of the sentence to the extent. I will repeat, I will have a to the undergone period and what fine amount he is supposed to be paid. I think this is sufficient for today. I will come again before you with the new episode, new topic. Thank you. Thank you very much. Thank you.